Lease and Order TV. Real tenants. Real landlords. Real justice.
Title of this case is Gary and Mary McLean versus Colleen McPherson. And you're Gary McLean.
Yes.
And you're Mary McLean.
Yes.
And you're Colleen McPherson.
Yes.
Also present is Pam Kirkland from Adult Protective Services and Tori Laughlin from Commission on Aging and Megan Bauer from Legal Aid. Also present is Douglas Kuhlman, the is this Fabius Township?
Yes, yes, it is, Your Honor.
Zoning administrator. So there's more here than meets the eye. What the case is presented here as is a termination of tenancy. This is a property at 15271 Mooney Lake Road in Three Rivers. It's in Fabius Township. I'm familiar with this property. There were some small claims cases and other things out there. The McLeans have a small farm there. They want you to move, Miss McPherson. This is called a termination of tenancy action. You are a defendant in a landlord-tenant case regarding termination of your tenancy. And as such, you have certain rights as a defendant in a landlord-tenant case. First of all, you have the right to hire an attorney. If you cannot afford an attorney, one may be available from Legal Aid. And one of the faces on the screen is Megan Bauer from Legal Aid of Kalamazoo. So she's monitoring what's going on here. And if need be, I can put you in a place where you can talk privately with her. We've also got the zoning administrator from the township, and we've got Adult Protective Services and Commission on Aging. You have a right to have the case heard here in St. Joseph County where the property is located. I don't know why I have to tell everybody that because it's never been an issue even once, but I am required to advise people of that. You have a right to demand a jury trial. If you want a jury trial, you must tell the court at this first appearance or file the demand in writing within 5 days using the appropriate court form and be prepared to pay the $50 jury demand fee unless the judge waives the fee for your inability to pay it. If both parties are interested in mediation, the court can help set that up and make a referral to the Citizens Mediation Authority. You may be able to reach an agreement with the landlord that means the case would get dismissed. The court must provide you with that information to prepare a conditional order of dismissal, or perhaps one of the attorneys would prepare it if there is one. All right, Ms. McLean, at this point, you're all living in the same house at Mooney Lake Road. Is that correct?
That is not correct.
All right. Is this the apartment in the barn?
Yes. And when we got our permits in 92 from Mr. Niken, we permitted a farm dwelling inside the barn because we intended on doing livestock and needing agricultural help. So that was built in 93. And I have the original building permits with me.
All right. Is there a lease?
No.
Does she pay rent?
She did a little bit. Mr. Kuhlman pointed out to me that my kindness gets me in trouble every time because he's known me a little bit through this.
It's called no good deed goes unpunished.
His exact words.
I think you heard that from me.
Yeah.
All right. So at this point, how long has she been there?
In January, she appeared with not a dollar to her name and her belongings in a snowstorm, and I allowed her to move in with nothing.
Is she related to you?
No.
How do you know her?
I had known her through Facebook for 2 or 3 years. She'd come out a couple of times and visited, and when I had different things open, and then we visited just prior to that because my goat birthing season was coming on, and my Mr. McLean loves to be able to go away for a little while in the winter, and some of my farm help is to help with whatever's going on. And oh, she'd be so wonderful help. She'd help me with the birthing of the goats and this and that and the other. And seemed like a very nice woman. She only had one pet. And
all right, well, we don't need to get into this issue right now, but let me ask Mr. Kuhlman, is this place lawful for habitation?
No, Your Honor, it isn't. And that's the whole problem. Back in May 30th of 2017, an administrative search warrant was executed on this same building actually the entire property. In May of 2017, this area was placarded as unsafe for human habitation. No enforcement action was taken at that time because Miss McLean was cooperating. I would just indicate for the courts that I do have 2 open cases coming up on September 23rd. Where on this occasion I did cite Mrs. McLean for 2 violations of township ordinances.
All right, well, let's talk about that. Miss McPherson, they want you to move. You don't have a lease, you're not paying any rent, and the township says you're not supposed to be living in there. Have you made any provision to try to move?
I've been trying to move out of there since February. I paid rent up until June 15th,
How much was the rent?
$1,000 a month. And I have,
Stop. So you paid 1,000 for January, February, March, April, May, and June?
yes.
And you disagree with that?
Absolutely did not pay that.
All right, well,
I did set the rent at 1,000 in February when I could see she would be of no use to the farm and high so that possibly she might find a place to live. And she was amicable in the beginning.
all right, well, obviously, at some point, you're gonna have to move out of there. So let's hear from Miss Kirkland of Adult PS. Is Adult PS attempting to help her find a place to live?
We are, Your Honor, and that's why Tony Laughlin, she's with Area on Aging, victim advocate. She is assisting me in helping Colleen find a place. Colleen has been looking locally and as far as Kalamazoo as well.
Miss Laughlin, have you had any success with that?
We do have potentially an apartment, but it is gonna take a little bit of time.
All right, the law requires that I continue this matter for at least 7 days, which would take us to next Friday. Meg, this doesn't appear to be much of a legal defense. She's not supposed to be living there. They need to get her out of there. We're not asking for money damages at this time. And she's got 2 resources trying to help her find a place to move to. So, yes.
I know your position on this, but is it possible the notice is deficient?
Well, let's find out. First of all, let me look at our docket here. Next Friday would be September 5th. What's deficient with the notice?
I am not sure. I haven't seen it, but I do have some notes in front of me regarding this case.
Well, the notice to quit was filed July 16th. No, the complaint was filed July 16th. The eviction notice was something they got off the internet, which looks pretty good. That was served July 14th. So that may be the problem. The notice to quit was served 2 days before the complaint was filed. No, served on May 10th is what she says. So it was filed at the same time, but it was served on May 10th. That's what my note says. So it appears to be adequate notice.
Thank you, Judge.
At any rate, we're not arguing now about money. This is about possession. If you move and the McLeans sue you for rent, we could have another hearing. That's problematic. A, you've been placarded, so you're not supposed to be renting it. And B, you don't have a lease. So you may just pursue getting the property back and not worry about money damages. But let's see what we got for time for next Friday.
Your Honor,
Now, yes.
I did inform Colleen from the very first day that I couldn't just rent to anybody for any reason because of the zoning thing. So she immediately went right to Doug Kuhlman. I gave her the ammunition. But our apartment is in horrid shape right now. I have a video if we could play it. And My husband's cousin Sandy McLean Hummel is here because she was there.
Well, we aren't there yet. We're just about possession.
Oh,
So if you
okay.
get her out and you want to sue her for money damages, you have to file a separate action, probably in small claims court.
But every day that she's there, wow,
Go ahead.
it turns into a mess. She smokes incessantly. It has got maggots hatching out and flies and filth.
Yes, no good deed goes unpunished. So you put her in there, you don't have a lease, she's a tenant at sufferance. I can't just throw her and her baggage out on the street. We have to go through this process. You've been at it since May, and that's really a long time, longer than it should take. You have to give her 30 days notice. Then you filed the hearing in July. I'm sorry, it took all the way from July 16th till now, but I was gone for 2 weeks in July and then I was gone for a week in August at the judicial conference. So here we are in late August. But I have to continue this at least 7 days, and she gets 10 days from that date to move out. So next Friday is September 5th. September 5th is afternoon day, and I would set this for 2 p.m. on 9/5/25 for a second hearing. Now, if you move by September 5th, that's not likely. But if you do move, you need to turn in the keys and give your forwarding address in writing within 4 days of your moving. There is no lease, there's no security deposit. But you're gonna need to get out of there. Now, they've got some concerns about smoking. Is there a smoke detector in there?
She took them all down.
No, I didn't.
All right,
They're
well,
gone.
I don't, so I've got some concerns about fire hazard in a barn, but also she says there's cleanliness issues. You're ready to move, you would like to move, but you haven't got anywhere to move to. And so you've got 2 agencies working on moving you.
Yes.
And hopefully they can find something. Otherwise, we're gonna have this hearing, we're gonna address this next Friday by Zoom once again. You're all welcome to come here live. But we'll deal with it next Friday at 2 o'clock. The law requires that I set a second hearing. Didn't used to, but it does now. Then you get 10 days from that date to move, or you'd be subject to being evicted, which essentially gives you until September 15th to move. Or on the 16th, the sheriff could come out and put you and your stuff all out in the street. So that gives you 7 plus 10, 17 days from today. From either of the agencies, do you have any knowledge whether she was paying $1,000 a month rent?
I have no idea, Your Honor. It's just kind of been back and forth. He said, she said. I have
Ms.
no idea.
Laughlin?
So Ms. McPherson did provide me with the text communications between herself and Mary since January. An extensive amount of communication where it was indicated and confirmed by Mary in text that she had been paying $1,000. They had an agreement about what the $1,000 would cover. There are some issues that about the notice to quit, kind of all of it. I mean, there's a lot. So
And you're not being picked up very well. What's your concern with the notice to quit?
So the paperwork that Colleen had received, it was back to back to that 30-day notice that said that was sent on May 10th. Served. On the back of that was a 5-day notice that they served on July 14th. That was the most recent notice. And then 2 days later, they filed the paperwork here.
Yeah, I think the notice is sufficient. If she served one on May 10th, and then she served another one on July 14th, the May 10th one would supersede, and she's got more than enough notice before the complaint was filed. At any rate, she needs to get out. She's not supposed to be living there. They're not supposed to rent it. There are some health and safety issues. There may be some money about whether rent was paid or not, but we're not about money at this hearing. We're about possession. And so once she vacates, if you want to sue her for money, you're gonna have to file a small claims case. But since it wasn't supposed to be rented in the first place, that may not go very far. So what you just may need to pursue is possession. All right, everybody on board, we're gonna deal with this next Friday at 2 p.m. All right, we'll address it at that time. And you're welcome to come back live again or appear by Zoom.
Your Honor, do you have any need for me to be in that hearing or no?
No, I don't.
Thank you.
I do have something that I'd like to talk to you about. Did you get a complaint from a guy named Jeff about a property on Moore Park Road? Excuse me, North Fisher Lake Road?
Not that I'm aware of, Your Honor. I can check with Mike, and would you like to email me an address, or I can contact you later if you'd like?
Yeah, yes. It adjoins my property, so I may, if it comes a case, I'm not gonna be able to handle it. Yes. All right, yeah, I'll talk to you at some point outside of this. Ms. Kirkland, thank you for being here. Mr. Pullman, you don't need to be here next Friday. Ms. Kirkland, I hope you can find a place for her to move to and maybe solve this problem.
Well, we're trying, Your Honor, and I'll be back on Friday as well. Thank you.
All right. From time to time, I do make adult PS referrals myself when I've got people that are in a position where they can't find housing or they're otherwise being left in distress. Problem is, it's so hard to do it. You have to do it through the state central agency, and it's not as clear as it once was. Well, we're a little behind, but let's see who we've got. We've got Mr. Cromendike on behalf of Golden Ponds Estates. We got KC Villa. We got Crystal Gray and Crystal D'Amata. Rich D'Amata, which case are you here on?
Should be on mine, Your Honor, I think.
Oh, yes, she is. Calvin Williams and Felicia Wiley. They are not here. So let's talk to Crystal Gray. Let me make a note here. This is 251570 LT, Golden Pond v. Gray. Mr. Cromendike is here on behalf of Golden Pond, their manager, Casey Villa, and tenant, Crystal Gray. All right. Ms. Gray, you're a defendant in a landlord-tenant case. This is a little different than our last case. The last one was the termination of tenancy. This is a demand for payment of rent. In such a case, you have a right to hire an attorney. If you cannot pay for one, the legal aid attorney may be available to assist you, or you could seek some other legal assistance. You have a right to have the matter heard here in St. Joseph County, where the property is located. You have a right to demand a jury trial. If you want to have a jury trial, you must tell the court at this first appearance or make the demand in writing within 5 days of the court explaining it to you, and pay the $50 jury demand fee unless the judge waives the fee for inability to pay it. As a non-payment of rent case, you may be eligible for some emergency financial assistance from the Michigan Department of Health and Human Services, a local coordinated entry agency that's in Battle Creek, and a housing assessment and resource agency that is Neighborhoods, Inc. Or if you're a veteran, you may be eligible for veterans assistance. You do not need a judgment against you, despite what the DHS might tell you, to get this assistance. You may be able to reach an agreement with the landlord by going through mediation. If both parties, the landlord and the tenant, are interested, that's never happened once, but it might, I can refer and help set that up. You may be able to reach an agreement with the landlord that means the case would get dismissed, in which case we would provide, it's called a conditional order of dismissal. This is one of those lot only non-payment of rent cases. Mr. Cromendike, we spent a portion of our time at the judicial conference earlier in August on this very topic, whether you can file a demand for rent and lot only in a mobile home park. We discussed this before. I think you sent me a brief from your law firm regarding this. One of the judges in Livingston County shared an opinion where she opined that you can't do it, and she dismissed the case outright. That the only remedy in these cases is the just cause termination for 3 lates in a 12-month period. There is a dispute, and the law is not clear with any of the change in the law, change in the court rule, or a piece of legislation to clarify it, or even a court of appeals case. I've been struggling with it because there's no detriment to the defendant. It allows the defendant to redeem it and keep the property, as opposed to a just cause termination where the only option is to move. And they really don't want the tenant to move because mobile homes are not mobile. Mr. Dutka had represented Golden Pond himself for a number of years, and he's also familiar with this issue. Anyway, it is in flux. So let's assume for the time being that you are able to do this. What is the current arrearage?
Total in outstanding rent and late fees is $1,226.42.
Give me rent.
Yeah, I don't have the full breakdown between rent and late fees. I have the full ledger, but I'd have to go through and do the math to break out the actual rent versus.
What are the late fees?
Let's see.
$300.
Late fees are being charged at $60 a month.
Oh, you can't do that on a $395 rent.
What number do you go with? 25?
Well, I went with 40 and then I went to 50. It isn't even clear whether you can even charge late fees, but all right, let's use your figure for the sake of argument. Give me your number again.
$60 for late fees.
No, but what's the total?
Oh, the total amount is $1,226.42. That's rent, late fees, some utility fees, some credit card convenience fees. Yeah, and that it's composed of kind of those categories there.
Well, we're gonna have to break this down at some point.
Yeah,
she doesn't
agreed.
know how much is rent, how much is late fees, how many are the late fees? Can you charge that much?
Yep,
how much
and
are
I've got
utilities?
I've got a full ledger I can look at with her.
All right. At any rate, we know the bottom line, and then the court costs are what?
Court costs are $249.20.
And what's the total?
That's a total of $1,475.62
through August.
Correct.
Miss Gray, what's your intention here?
What do I think? I have it all broke down for you, Your Honor. As far as rent paid and everything, and I dispute the charges, I guess, because I don't understand how it's all adding up. I've paid $19.31, and I should only owe $19.75. So in rent wise, $60 is what I come up with. I just graduated college this month, and I'm planning on getting it caught up as soon and as fast as I can. But I don't understand
how much do you believe you owe $60?
Yeah, with rent, just as far as rent, not including the water that we can't drink or the late fees, the $300 in late fees. And they're also charging us twice to make a debit payment.
Slow down. So
Sorry.
You believe you owe $60 in rent. Now, Mr. Dutka is aware of this. There's been water problems at Golden Pond Estates for many years. Mm-hmm. I had a case once where they brought in water from the pond, which was cleaner than the water from the tap. And there were other problems. They put in a septic system, which was actually on the neighbor's property. And this precedes you, Ms. Villa, but a previous owner, they put in a drain field and a septic tank, which was on the adjoining farmer's property. But there's always problems when you have a concentrated group of dwellings flushing their toilets and drawing their water out of the same groundwater source. So there's been problems out there for a long time, but I don't know what the current status is. At one time, the health department considered shutting the place down, but they didn't want to make all the people out there homeless. So I think it's better than it was. An owner made a number of improvements. I think I'm not even sure which generation of owner we're on, but any rate, there's been issues regarding that. So we got a bunch of issues here. She contests the amount of rent owed. We threw some spaghetti at the wall to see if it will stick. I don't know how much is rent. I don't know how much is utilities. I don't know how much are late fees. But Miss Gray, the law requires that I adjourn this matter at least 7 days. And then there's an underlying issue of whether they can even do this. But let's assume that they can. If they filed a just cause termination, that there were 3 lates in a 12-month period, the only option is for you to move and then 90 days to move or sell the mobile home. So there is some benefit to allowing the landlord to proceed in this way, benefit for the defendant. When emergency funding was available, there was a substantial benefit because they wouldn't give you any emergency housing funds if it was a termination of tenancy. If it was a non-payment of rent, they would allow funds to be used to pay the rent. So, like I said, we've been struggling with this issue for a long time. At any rate, we need to continue this matter to 9/5/25 at 2:15. Now, by that time, Ms. Cromendike, there will be another month's rent due. So you might as well just take that figure of $1,400.75 and add another $395 to it.
Correct.
So and I'm disputing that number because I'm probably going to reduce the late fees and I want to see what the utilities are. But 1475.62 plus 395 is 1,870.62. So it'll be about $1,800 that they contend is due. Now,
Chris,
we've got another case to do. I'll call that. Do you think there would be any benefit, Mr. Cromendike, for putting you, Miss Gray, and Miss Villa all in a breakout room to try to hash out those numbers?
Yeah, I think that would be great.
All right, Miss Gray, you stay with me because we have another case, and I'm going to let you guys talk to each other in a breakout room.
Thank you.
There does not appear to be anybody here on behalf of Golden Pond versus Fox. This is Golden Pond Estates versus Amber Fox. Excuse me. Try not to sneeze. Again, lot only. Let me make my notes. She was personally served. Let's make sure she's not outside. Good morning. I'm looking for Amber Fox. All right, thank you. She's not here. This is also a non-payment of rent case. The defendant was personally served. What's the arrearage here?
Total rent, utilities and late fees is $1,926. I again would note that we are going to have the same late fee issue as we did on the last one, and I'd be happy to give you a full breakdown after. I'll reduce the late fees down to 40.
Okay.
That number may go down, and then court costs are $273.69. And so that's a total judgment amount of and amount to retain of $2,199.69.
How many late fees are in there?
Well, it's hard to tell because the balance has not been zero since for over a year ago. There's been a running balance since at least June of 2024.
Late fee is $60 in the lease. I'll allow 50. Says lot only.
I will adjust that based on the $50 number.
So it sounds like it'll be reduced by about $100. She's not here. She was personally served. Is Miss Via, is she still there? Your microphone is on.
She's still living in the property.
All right. All right, by default, I find that the defendant owes, I'm just gonna put a number on it, $1,826. I reduced 10 late fees. 273.69, total of $2,099.69. They have 10 days from today to pay the rent, or the mobile home is subject to being moved. And it's her house, and this is mobile home only. So this is where the problem becomes, because no one ever moves the mobile home. I don't know why she's not here. The date for the writ is 10 days from today, which would be, today is the 29th. It would be September the 8th. All right, I'll need a judgment. You can email it to me at the address on the notice, which is 3B Civil at stjosephcountymi.gov.
I will get it into you this morning. Thank you.
All right, I don't know. The judge who wrote the opinion in Livingston County was very well analyzed. I've received 2 briefs, one from, I think, the Cox firm and one from another, where they argue that you can do this. We'll see. But now you've got your judgment, and you got to figure out what you're going to do about moving this mobile home. So generally, the thing works out somehow. We'll see where we go with this. All right, she isn't here. She's subject to default. Now, we have our other Golden Pond case that we addressed, Miss Gray, and I'm going to put all the parties in a breakout room to discuss narrowing down those figures. So Miss Gray, when the button to hit join comes up, you join. I'll be here if you need me further.
Do you want us to come back in to talk to you when we're done, or just
if you need to? Otherwise, if you're done, you can all just go, and I'll see you next Friday.
Okay, thank you.
All right, thank you.
Thank you, Your Honor.
Thank you.